I'm Dr. Barry, licensed psychologist, and here we talk about true crime and psychology. Thank you so much for joining. Let's hop right into today's topic. Let's go.
Welcome. Today we are talking about the criminal case regarding Ebony Parker. You'll also hear her referred to as Dr. Parker. She was the vice principal or assistant principal of Richneck Elementary School. There is a description of this case down. So I have an overview of the case down in the description. Please also know that there is now an entire playlist just dedicated to the civil case, which the jury is going, they're not going to know anything about the civil case. And then, but this is her criminal trial. And this was a rare situation where the criminal case is coming after the civil case. But the criminal case was regarding Ebony's civil duty to the teacher that ended up being seriously injured in this incident. And the criminal case is about the children. So I wonder if that was part of the reason why we saw the civil case before the criminal case. Now, this case, oh my gosh, if y'all are watching, and so I'm gonna have to reach out to Tiffany and Josh because I would love to sit down with Josh Ritter to have a conversation about the back and forth with the attorneys because they are doing speaking objections. The jury is getting confused today. So at the end of today's hearing, the jury had questions. One juror had a question about something that happened and they weren't able to fully ask the question. So they're going to have to write it down and submit it to the judge. The judge is going to discuss the question and how to respond based on the law. And then maybe they may be able to answer that juror's question, but another juror asked their question out loud. The juror was like, what if we have a question about what we're not supposed to be paying attention to? Because there were multiple times where some things were sustained and they were like, times that things are being allowed. And I think the jury is getting confused. I would not be surprised if the defense asked for a mistrial, which would be, because they'd have to go through the whole jury process all over again. This was day one. This was day one of testimony. I think people would be more prepared. So I personally think now the defense, because they've given opening statements, we know that in this case, Dr. Ebony Parker, her team is saying that she wasn't the only one responsible, that the teachers could have done something, that there were other people that could have done something. And the fact that I don't know if they're going to, I guess they don't think the state can fully prove that she did nothing. Based on the civil testimony, that's pretty much what the testimony was. And some people were able to kind of sneak things in. And so I will be breaking some things down from today. Today, there were times that was confusing. It was annoying. And so they should be doing sidebars outside of the presence of the jury. And the state was even like, hey, maybe we should maybe we should voir dire this witness outside of the presence of the jury. Because they're up here, everybody's just saying things and then they're deciding, do we let it in, do we not? But the jury's already heard it. And it is very hard to unring a bell. JD Explains, he's another lawyer here on YouTube that I follow. And he often says, if you tell the jury not to think about the pink elephant, all the jurors are going back in the room thinking about the pink elephant. You can't unring it once it's out there. It's really hard to undo that. And it has been interesting today. It has been a lot. There were times I had to take a breather. I had to take a breath. I am passionate about this case because I covered this one over on so I covered the civil trial. So Courtroom Confidential Trials stream this live today. So that would be the channel that I would recommend. Has a great chat. Of course, Court TV, Law and Crime, everybody else is streaming it. I haven't loved the chat experiences on those channels. So I would personally recommend Courtroom. Yes, Courtroom Confidential Live Trials is the channel, and I'll make sure to put a link to it in the description later today. Oh, there were so many objections, so many objections. But then the judge is like, so what are you objecting to? And they're arguing in front of the jury things. And the jurors have said that it's difficult for them to hear the defense. And so it's been a day. And this is day one. Day one. All right. So let's start with opening statements. So the state starts out with their review and really their belief that the assistant principal, it was her job to do something. So there was suspicion of a weapon in the building and nobody was notified. And teachers on their own. So the reading specialist on her own, she decided, I'll search JT's backpack. And we're talking about a first grader. So this is an elementary school. And I honestly think Dr. Parker did not think it was possible for JT to have a weapon. But unfortunately, JT's mother, and she spent 3 years in jail for leaving an unsecured weapon. And I think he might be in the custody of a grandparent. JT, I believe, did some intensive treatment. And so people are making sure that that child is okay, because in kindergarten, it hasn't come out fully yet, but in kindergarten, this same child, JT, he choked out his kindergarten teacher. She went to bend down and he came up behind her and he choked his teacher really, really hard. And so, and then he was suspended, I believe, for the rest of that year. And then the way he made it back into the building, I believe his mother was supposed to be there. There was a behavior plan of, if he's in the building, I believe his mother was supposed to be with him because he had significant behavior concerns. Some of that may not make it into court. Okay. Because some of those things are very, very prejudicial. Okay. The principal did testify today, and I will talk about the principal's testimony. Okay. But the assistant principal was the person that was notified. Often assistant principals in Virginia, they handle discipline. But if it's a major safety concern like this, they would include the resource officer, so security. They would also include the principal, and there are protocols to follow. So, at some point, the safety protocol for the school, it looked like they tried to admit it through the former principal. That principal is no longer a principal at that school. I'm not sure if they're a principal at any school. But this whole thing has just been a lot. Hey, Mama. Mama's in the chat. All right. So I am going to get back to this. So the defense is saying the teacher, the other teachers, anybody that had suspicions had the authority to separate the child from his classmates, and they want to push the blame onto other people. So remember, the defense is going to do what the defense does. Okay. So they are saying, why are we holding Dr. Parker accountable for all of this? This was something that would have been very difficult to foresee. But the expectation is that you do something. That there is a duty to do something. And we'll see. But based on the testimony from the civil trial, and we'll see what comes in during the criminal trial, because this defense is objecting a lot. They're trying to object to hearsay. They're trying to object to a lot of different things. Some people feel like the judge is on the defense's side, but honestly, the judge is trying to be on the law's side so that they don't allow something in that then overturns the entire trial and the state has to do everything all over again. So the very first witness was Abigail Warner, and she looked less anxious. So during her trial, she seemed very anxious. I did watch today's testimony on 2 times speed because y'all know, and I did slow it down at one point because it was coming across different than her testimony in her trial, but when I slowed it down, it was the same. So it was coming across in a different way to me because I had it sped up. Because there are times that you can tell that she still has significant trauma related to this event. Sometimes it's difficult for her to remember. Sometimes it's difficult for her to answer questions. And to me, as a psychologist, that was evident that she is continuing to heal from this incident. They did not go into the extent of her injuries, and that would have been inappropriate because Dr. Parker has only been criminally charged with failure to protect the children. So she's been charged with felony child neglect, I think. I think that's the charge. I have the charge in the description if you need to check. Okay. Oh, watching your first live. Yay. You normally catch replays. Welcome, welcome. All right, let's see. And the school districts have legal immunity. So the parents attempted to sue the school board, and I believe their lawsuit was thrown out. They did fire the superintendent. So a bunch of people got fired. In the midst of all of this, teachers were extremely upset. They did not feel safe because and so my uncle used to be a teacher in the Newport News, in that school district, and he might have known some of the I don't know, but I won't go into that. I know an individual that is on. I've never met them personally. I know their mother. So somebody that is going to testify, their mother was my supervisor. And I do not know the individual that's going to testify. I'm not going to talk to them or do the same way I didn't reach out to anybody related to the last case. I only talk about cases when there is distance. So if I was working with a student that was a victim of this incident, I would not talk publicly about this case at all. So I'm very strategic with the cases that I cover. This is in Virginia. I'm in Northern Virginia. Hampton Roads, Newport News is more in Southern Virginia. Okay. So that's how this is going. So let me pull up my notes again. So there were a ton of talking objections, so many talking objections. So Abigail Warner gets on the stand, and the defense is objecting because she's going to try to say the other people told her that the student may have had a pew pew. And this student had broken her phone and gotten suspended. So she goes over the incident, and the defense does not want that to come in either. But this student was returning from his first day of suspension after breaking Miss Warner's phone. And his decision was to bring a pew pew. And if you look deeper into this case, I believe the student says something to the effect of like, is that bee dead? Or I would have like the student was in that moment. So I think the student had major anger problems. At 6 years old, they can't understand the finality of death. This student was likely exposed to many things within the home. And now I hope that they're in a safe place, that they've received treatment, and that they're on a much better path. I do hope that's where things are. Later today, we're going to talk about the Netflix documentary Crash and permissive parenting. We're going to talk a bit more about the importance of love and boundaries in parenting. That permissive parenting can really, it's not good. Yes, the student was 6 years old, and it's my understanding, and I don't know if it's going to come in. So they're keeping some statements out. So some things came out in the civil trial that haven't come out in the criminal trial, and I don't know if they will. And it might be appropriate that it be kept out, but it's my understanding that when people were coming to Dr. Parker concerned, she made a statement, something to the effect of, how big are his pockets? Because people were saying, we think he has the weapon on his person. We think it's in his pockets. And that she made some statement like, how big are his pockets? I'm going to stay on track with talking about Abigail Warner's. And so she is the teacher that was shot by the student. She survived. And that's only because the gun jammed. So I think there were a total of 8 bullets that cut. So after the first shot, the gun jammed, and I believe that's the only reason why she's alive. Um, uh, yes. Okay. Oy. So, the defense tried to confuse her at times, I think, but like, and once again, so the defenses are going to do what they're going to do. And, um, the defense wanted parts of her testimony thrown out because they were trying to say that she said she was told that he had a gun, and like there was just a lot of confusion back and forth of what did they say, what did she say, what did who believe, and there was just all this argument. So there would be like one sentence said and then 2 minutes of arguing, and then the judge would make a decision, and then one more sentence, a question, and one sentence said, more arguing. It was so much back and forth. It was very, very painful. I really hope they do some sidebars. You know, if anybody's watching, if anybody knows anybody related to this case, please do a few sidebars. Please do a few sidebars. But it's just my personal preference. Because when you do this in front of the jury, sometimes both the state and the defense can say what they want to say, and the judge might rule against it, but the jury's already heard it. How can they unhear what they just heard? Like, it's just, it seems confusing to me personally, but it is what it is. So then the defense really wanted to say that it was Abigail's fault, that she didn't remove the student, that she didn't take the others, that she didn't separate him from the other students, that she didn't bring him to the office. If she had attempted any of those things, this student was homicidal towards her. And she didn't go into that. Like, this student, if she had told him, I'm taking you to the office, that would have escalated this incident. And she didn't have the words to say it. Somebody else, another teacher later, did have the like state of mind to say, no, you wouldn't confront a student that you believe is an active threat. You would make sure that there's safety procedures in place first as a teacher, because I could escalate things and it could be made way worse. But so defenses are going to do what they do. And so that was kind of what they were doing. And they go into because she did take him to the office, or like somebody took him to the office after her cell phone was broken. And so the defense tried to put it out there that like, they didn't say it, but it was like they were hinting that she had a bigger response to her cell phone than the possibility of there being a weapon. But for a cell phone, that's property destruction. I believe she called, somebody came, took him to the office. But with this situation, they needed a security officer or the police. They needed somebody to come, or the principal or vice principal to search his person. They needed somebody to do those things. And it just is. So it's my understanding that the other students that were in the room, many of them received counseling after this incident. Many of them are probably still in counseling, sometimes for students involved in situations like this. We've seen testimony from older students. I believe they're going to get some testimony in through the parents. I think they're going to try to keep the kids off the stand. And not have the kids go through this. I think that's how they're going to handle it. The defense's questioning has just been a lot. Side quest, squirrel moment, real quick. The one thing I'm going to talk about as I talk about the crash documentary, I'm going to try to center the victims more, and how parents, if your child is involved in a toxic relationship, I want to take it more from centering them than centering the perpetrator and of that incident. And I do have some thoughts about her appearance. Like, we're going to have to talk about her accent, and like, we're going to have to talk about those things just because we have to. But I'm going to try to center them more in that conversation. Back to this case. Okay. All right. So I love the chat. All right. So once again, the defense was trying to say her response to the cell phone was stronger than her response to a possible firearm. She did not personally notify administration, but the students told the reading specialist that they saw him with a weapon. I think that was after lunch or right around lunchtime. A student told the other teacher that they saw bullets during and that he had a weapon during recess. And so she did not personally see it. She was aware that there was suspicion that he had something, but she didn't personally see anything. She wasn't personally told anything. And so the defense said the teacher has the first responsibility to protect the students. And she didn't fight back with that. The next teacher will. The next teacher. And so she'd only been a teacher for 2.5 years. Not to but she was a newer teacher. There's a more seasoned teacher that she's like, buddy, don't try to put this on me. And we will get to her testimony a little bit later. Okay. So hang with me here. So then Miss Kovak, the reading specialist, she had a really good relationship with JT. And after the pew pew incident, she runs in and she hugs him. And she's the one that disarms him and hugs him and holds on to him until the police arrive. She deserves, I don't know if she received any type of award, any type like for a reading specialist like that was not a part of her job. She could have proceeded with lockdown and waited for authorities to come. She saw the student that she had a good relationship with. I think she strongly believed that he wouldn't have harmed her. But she ran right in and she's the one that disarmed him. And the defense is going to have all the audacity, so much audacity to look at her and be like, well, why didn't you do more? But okay. So Miss Kovak is the one that also called 911, and she's holding him after the incident. And so then the defense objects that this is more prejudicial than probative. The defense does not want them to talk about the aftermath of the incident. And the judge said some stuff would be kept out and some stuff wouldn't. I didn't even pay attention because I'm not a juror. I didn't have to pay attention to what the judge stopped and what the judge let in. Because a lot of the hearsay the judge let in, some of it she didn't. It was, and they would argue the law. They would argue the law right there in front of the jury. And I follow a lot of trials, and there were times I was also very, very confused. Miss Kovak truly, truly is a shero. She's just phenomenal. And Miss Kovak did. I think the defense was trying to say that it's the teacher's responsibility to keep the kids safe. It's their job to manage. Oh, that's where Miss Kovak was like, they manage disruptive behavior, but not a safety concern. If a student has a weapon, it's not in a teacher's job description to disarm a student. No, that's the SRO. Somebody else comes in to handle that situation. I used to do intensive home-based therapy, and if there were weapons in the home, I would ask the family to make sure those were secured. I had some students that were on where we wanted sharps and knives and things locked up because they were a safety risk. And there were situations where, because of my relationship with a student, I was able to disarm them sometimes, but sometimes we had to call the police. As long as they weren't actively harming somebody else, our first step was, okay, they're not being safe. They have a weapon. Sometimes I would ask the parent to try, it depended on where the anger was being was going to how we handled situations. And I have mental health training. Like, I am trained in crisis response. I'm trained in a bunch of different things. Teachers do not receive all of that training. They do receive de-escalation training. Sadly, we do have to teach teachers how to respond to active shooter situations. Often we think elementary school teachers shouldn't have to deal with that, but many unfortunately do. And there have been other schools in Virginia where a weapon was found in a child's book bag, where an adult sometimes accidentally, or I don't know, for some reason, the adult put the weapon in the child's book bag, or a child didn't realize that it wasn't a toy and they picked it up. Please make sure, if you have weapons, make sure to have locks, make sure to secure them. I just saw an incident where a 3-year-old um, uh, shot and killed a family member with just an unsecured. The family member was asleep. The 3-year-old picked up the weapon, and it was that family member, the family member that died. It was their weapon, and so just make sure, lock up things. It's just better that way. But okay. So then the defense tried to be like, that she mentioned to somebody that it could have been a toy. And even if it was a toy, so in Virginia schools, you can't even do this. Like, a kid could be suspended for going pow or bang. Like, I tell my kid, make sure, because he has little, like, we have like Jedi swords, and normally a Jedi sword might be, not sword, but like a Jedi lightsaber would probably be okay, but not like pirate knives, or because even toy weapons are considered to be inappropriate for school, and they aren't allowed to have them. And so even if it was a toy weapon, it's still on the admin to make sure that child is searched and that there's appropriate follow through with whatever they have. Because the defense tried to minimize, because they were like, oh, if it was a toy. And she was like, well, it could have been a BB gun. Like, BB guns can hurt people. And the defense seemed upset about that, but like, they asked the question. And sometimes they would get upset about responses to their questions. And by the end, the state and the judge are looking at them like, you asked. Like, you asked the question. Ooh, Miss Kovak was very talkative. She, I think, has very strong feelings about this. I think she likely feels like the administration let the entire school down. She's probably not a fan of Dr. Parker at all, and that was clear. But some of her testimony could have come off like, because she was so passionate that things went so bad, that like she was answering her own questions. Because at one point, Miss Kovak and the defense, they argue. If you go back and watch, it's about halfway through cross, her and where the judge has to step in and be like, let's breathe, let's rein it in a little, because they were going at each other. Mental health first aid is for responding to a crisis. So we know there are things people can do in the immediate aftermath of a tragedy, of a trauma, like of a tragic event, that can help people's mental health. And one of the biggest things is talking about resilience, talking about post-traumatic growth, and mental health first aid. Often mental health professionals are trained in it. Do you think the race of the student and the teacher involved impacted how Dr. Parker responded? So I believe Richneck Elementary is likely a predominantly African-American school, and the assistant principal, so race is not going to come up in this case. It's not going to come in the back of our minds. Sometimes we're wondering, did she think the teacher was just being dramatic and like just couldn't manage this student and maybe wasn't meant to teach at that school? That's never been said. That's pure speculation. Nobody has ever said that. But when you ask about that role, if it had been a different teacher, would she have had a different response? But it's my understanding that in the past, so the teacher the kindergarten teacher that ended up getting physically harmed by him in kindergarten, they were going to put him back in her class. And she was like, no. No. And so he ended up, I think that was when they ended up finding an alternate school placement for him, and all of that. So I don't think it was just this teacher. It does seem like a possible failure of admin, my pure speculation. Do you know if teachers get mental health first aid training? So it depends on the school district. Often there are school social workers and there are school counselors that do receive that training. This student had a school counselor. So Mr. Rawls was the school counselor that would escort him to breakfast, that would escort him to different classes, that Mr. Rawls was the one. This testimony has not come into this trial yet, but when they call Mr. Rawls, I don't know if he's going to try to say that he tried to ask Dr. Parker if he could search the student's person. The state is probably going to try to elicit that testimony. The defense is probably going to object. I can, just based on how the beginning of this trial has went, I'm guessing the defense will probably object. So the student, the parent was charged with a crime. And I do not believe the parent has custody of this child. I do not believe the parent does. Yeah. It sounded to me like his behavior should have triggered bigger questions, interventions before this event. So it was first grade. They haven't talked about if he had an individualized education plan. He likely did for behavior problems. He was already meeting. I think he did, because they talked about him going to a SPED teacher, to a special education teacher. He likely needed to be in a therapeutic placement, but honestly, he was likely exposed to things at home. Because it's my understanding that, okay, so this is pure speculation, okay? The family will probably deny this because there is an interview of the mother and grandfather that's out there, but there is speculation that the mother was afraid of either her boyfriend or his father. There was a male that wasn't in the home that had been, there was DV between mom and that individual, and the mom taught him how to use the weapon. Pure speculation. Pure speculation. Those are things that have been said out there, and it's never come into any trial. And the mom would probably deny that, but if she admitted to it, that's a big crime. Very, very big crime, because the mom tried to fight her things. My uncle, that's a teacher. Hey, uncle. He did have an IEP. I thought so. Hey, uncle. Did you watch the trial? This trial has been very difficult to watch because, in my personal opinion, you cannot put it all on the teacher. Once an admin knows, it was hours. It wasn't like admin was notified of a problem and the incident happened within 5 minutes, within 10 minutes, within 1 hour. I believe it's over 2.5 hours. I think it was a long time between. I think there were hours between the first report of a student may have a pew pew, and that a student saw it. So Dr. Parker didn't ask to talk to those girls. She could have asked to do that. If so, she was doing SOL testing. I don't know if that's going to come up in this trial. I don't know if that's going to come up here. And while SOLs are important, safety of the school comes first, comes before everything else. You break every protocol. Students might have to retake. I don't care. Like, safety of the school comes first and foremost above everything else. And so, yeah. All right. And I don't think that Dr. Parker, I think she honestly thought it was like, he didn't really have a weapon. What are the chances? He's a first grader. Like, y'all already searched his book bag. Y'all already. I don't think she thought there was anything wrong. You'll also hear from today's testimony that once there were shots fired, she locked herself in her office. She did not run to the situation. And we don't know what she did in her office during that time. We do not know if she will testify. she might. So she has stayed silent. So during the Abigail Warner, the teacher's civil case, Dr. Parker, because her criminal case hadn't happened yet. So there's no way she can get on this, because there are things she could say in this case that could hurt her in her criminal case. So she, did not take the stand in the civil case. I don't know. I don't think it would be helpful for her to take the stand, but she could. Because if she takes the stand, the state could question her on what did you know? What did like they could kind of go into things more. I personally think she's not going to take the stand, but I could be wrong. I've been wrong all the time. If she does take the stand, I am here for it. I want to see it, but it's the content creator in me. That is not legal advice. And I can't give legal advice anyway. I'm not a lawyer. I'm a psychologist. I can't give y'all mental health advice either. Is that so SLS testing? I don't know if that's hopefully somebody answers. And so, I don't think the race of the assistant principal matters. So I think even if the person, I don't think the race of the assistant principal matters for this case. If an admin fails to do their job. So currently the state of Virginia is looking at making failure to report child harm in a hospital a jailable offense, because there was this big case. There was a huge hospital that had I don't know if she was a nurse. I think she might have been an ICU nurse that had been harming children for years. Children were mysteriously having broken legs. Kids in the ICU or the NICU. It was either NICU. It might have been the NICU. Kids in the NICU were having these mysterious injuries. And it turns out this nurse was harming the children. And so our state legislator is currently looking at possibly making failure to report child harm at a hospital a jailable offense, which is going to make a lot of false complaints go up. Unfortunately, sometimes that's what happens, but at least you would catch problems faster because nobody suspected. Family members complained enough that finally somebody looked into it. And then finally somebody realized, oh, this nurse has, I think it was more than 20 victims. There were a whole bunch of kids that had really weird injuries because of this. And so, yeah. All right. And so if you disagree, feel free to say, in my opinion, and then just, if you choose not to go back and forth in the chat, that's always your option. Thank you for being a member for 3 weeks, for 3 months, my brain. This is here in my home area. Wow. Thank you. Nice. Yes. So I am native to Virginia as well. I graduated from a high school down in Hampton Roads. And like I mentioned before, my uncle is a retired Newport News teacher. Now, there are some teachers. So if I used to be the therapeutic day treatment, there was a school-based therapy program, and I had between 10 to 25 counselors that were in 14 different middle and high schools. And with that program, if one of my counselors had said, I strongly suspect this student has a weapon, the admin isn't doing anything, I would have said, call 911. call admin. Hold on. I'm calling the principal. I'm calling 9. I would have, but that's just my thing. I don't know that any teacher will ever, if there's a suspicion, I think people will report it. And it was also the school resource officer, which is our school security official. They were not on campus that day. So they went between 2 campuses, but the administration could have called the officer to say, hey, we have a possible security situation. We need you over here ASAP. There's a potential there might be a pew pew. And that he probably would have called dispatch and sent the closest officer over to that school to handle that situation. They could have done something. Okay. All right. Oh, so I don't know the motive for why the person, so back squirrel moment for the NICU thing. I think she was just sadistic. I'm not aware that it was a funding thing for the NICU. I did not dig deep into that because it's hard for me. Those are innocent babies, and this I don't so I personally did not follow that case closely. I saw jail time law proposed for hospitals not reporting child harm, and so that like raised my eyebrows, and so yeah. All right. So then the Brianna Foster, the former principal, she testified, and they tried to admit the crisis management plan. This event happened on January 6th of 2023, and she never was told that there was even suspicion that a student had a weapon. And I'm pretty sure the crisis plan says if there's a suspicion, like you have to include the principal. So the principal was not aware when she heard when the shots fired, when one shot fired because the gun jammed, the principal was not aware that there was already suspicion that there was a weapon on campus. The principal did not know. Now, she's also had counsel because people have, because this has impacted her professionally, because this makes her look really, really bad. Because what do you mean? Like, now she didn't know, but like, nobody went to the principal. So as Dr. Parker wasn't doing anything, they could have went to the principal and nobody did. And so, but yeah, it's my understanding. So I thought the principal wasn't there. That's what I thought. She was there. She was in the building. She was in the building. She was in the building. Yeah. So, and that might be the difference between Georgia and Virginia, and then also with an elementary school. So, I believe in Virginia, SROs are able to search backpacks. Because I remember, because like if they have suspicion, of drugs or a weapon, and in Virginia, SROs are able to search backpacks. Colin Gray, yeah, Georgia. So the law might be different in Georgia. That's my understanding as a non-lawyer. All right. All right. So then the grandmother testified. So a grandmother was there to pick up one of her grandchildren, and she had two grandchildren at that school at that time, and she's there when they see the injured, like they know something's happening, and she encourages a student to hide. The student hides so well, they actually have difficulty like finding him after the incident. And the injured Abigail Warner comes into the office as well. The defense wanted to question her potential bias because she has considered suing Ebony Parker. So everybody probably saw Ebony. So the teacher received a like $10 million judgment. I don't know that she'll ever see a penny of it, but the teacher received a judgment against Dr. Parker. And so the parents, I don't know. So, but she said she personally hadn't reached out to the defendant's attorneys to discuss any type of settlement or anything like that, but she had explored her options, and she had retained an attorney to look at potentially suing Dr. Parker. Okay. If I was on the jury, it wouldn't have made me think that she's completely biased, because she was only testifying to after what happened after. She had no knowledge of what led up to this. She had no knowledge of everything else. And if I was a parent, grandparent, as a community member, I was mad that this situation was handled this way. So, all right. Then there was a forensic tech that did a phenomenal job. She was ready. Like, that was one of the quickest, like most straightforward witnesses. She gave the information about the weapon, and that was that. Then Miss West, another phenomenal teacher. She taught first grade and was across the hall from Miss Warner. She observed JT at recess, and a student, and he was just playing a little weird. And she actually took notes after this incident so that she could refer to it later. And she did mention that she looked at the notes to refresh her recollection, but that JT and another student, RR, that they were kind of playing in a way that had made her have some concerns. So she later asked RR about like what was going on. And RR said that he saw bullets. She asked information just like were they really bullets. She did strongly suspect that, okay, well, like nobody knows, but like, so she reports it to the office. She reports it to the music teacher, and then she wasn't able to say anything from that, but she called the office and it was reported to the person that answered the phone. And um and when the incident happens, Miss Werner's students run into her classroom and they lock the classroom down. The students, of course, so content warnings for children in distress. The children were terrified and crying. RR kept saying, "I told you. I tried to keep you safe." And that just had to be heartbreaking. Especially looking back now, she was very emotional during that part of her testimony. Understandably, she intentionally went out of her way to build relationships with students, and because RR was not in her class, RR was in Abby's class. And so there was some hearsay objections. Something wasn't allowed. I didn't write down what it was. I don't even know, because I don't even know. And I get why the jury is confused too. She was asked about by the defense. She was asked what steps should have been taken. Like if she believed a student had a firearm, wouldn't she take him away from other students? And she was like, maybe not, because that could escalate the situation and that could exacerbate the situation. And I was like, yes, that is. So if Abby had tried to take JT to the office, so JT did not like her. JT was not a fan. JT likely blamed her for why he was suspended. So he claimed he didn't break her phone on purpose. That's what he told his parents. I don't. He had a history of multiple behavior things, and that's where if I'm working with a student, I'm like, hey, we have to rebuild trust, because something is broken in the class. Everybody's going to think you did it on purpose, even if it was like you have to rebuild trust. We have to work on you being more in control of your emotions, your behavior, because if something happens, everybody's looking and like, was it JT? And all right. So she said it's also protection to not directly confront the situation in that moment and to allow admin and security to properly handle that situation, which I completely agreed with. I completely agreed with that. And so the juror wanted clarification on what had been stricken, and nobody knows. That's my statement. It's not. I would not be surprised if the defense asks for a mistrial. I don't know if they'll be granted one. I don't know if there's a way, because I think the jurors are confused with like, what were we allowed to hear? What were we not allowed to hear? Because they're arguing in front of the jury. So my non-lawyer recommendation, just somebody that watches trials, is when they disagree, objection. They say the reason why, hearsay. They say, because the judge is like, because they're given their explanation verbally, which is like, it's making it more confusing. So they need to have some sidebars. Judge, can we approach? There needs to be some more because they're not approaching the judge at all. I don't know if the courtroom is just too small. I can't remember it. Did they approach? I think there might have been one time. Was there any time they approached? There seems to be a lot of talking from the lawyer tables and not a lot of sidebars. I'm going back and listening. So if you watch the Corey Richens trial, there is a phenomenal creator. I want to say Corgi-san. I might be saying it wrong. But I have her video linked over on the community tab, and it's part 3 of her. She goes through day 1 through 4 sidebars, and it is entertaining. It was great to hear. she does little voices and has a ton of snark. And so I went back and watched, because I watched part 3 before I watched part 1 and 2. And so I did go back and watch those other parts. Also, if you followed Corey Richens, Guilty Words put out a really great video, just breaking down some aspects of the sentencing. And so I linked one of her videos on the community tab as well. Yes, Corgi-san. I might be saying it wrong, but yes, this is the spelling. She has, I think there's an S. So I think there's 2 A's. So yes. Afton did it correct. Yes. Ooh, my uncle. Because of VA law, Newport News Public Schools and the previous superintendent were severed from the civil lawsuit due to something here called sovereign immunity, which covered the school district and superintendent. Yes. So for anybody wondering why the school district and the superintendent were not also sued, it's because of this. All right. Thank you, Uncle. All right. So I honestly think there's more PTSD. So I don't believe in oppositional defiant disorder. This child had access to a weapon. He had exposure to DV in the home. There is suspicion of who allowed him. And so I don't think mom told him to take it to school. I don't think he was supposed to take it to school. I think mom was probably concerned if something was happening to her. She wanted, but you don't have your 6-year-old protect you. Like you just don't. Like that's not a good idea. There's some areas where they don't trust law enforcement as much. I don't know if that played a role in anything, but I think there were significant parenting things. And I also don't know what types of discipline was being used at home, because this child had severe emotional and behavioral concerns, and there are some parents that either don't respond at all, or they yell, scream, they hit the child. And this child needed help. So he needed intensive help. And I believe he went to, I think he's received treatment. He might, I don't know if he's still in therapy. I wish the family all the best, but I rarely diagnose oppositional defiant disorder, because what I find is, so children will reenact the trauma that they see. So a symptom of PTSD, especially in children, is reenacting. So the things that they've heard, this child cursed like a sailor. Like this child was completely like my 8-year-old doesn't know how to choke somebody out. Like he wouldn't know how to do it. Why does a 6-year-old know how to do these things? And so I think there were deeper concerns. Those are my thoughts. All right. So yes. I think he took it out of his mom's purse. And I think, yes, he took it out of mom's purse. Mom was not aware that he had it at school. And I believe Dr. Parker kept saying, his mom is on the way to pick him up. So the response, according to the teachers, because like I said, I don't know if Dr. Parker is going to testify. The teachers say that when they told her, hey, she was like, his mom's on her way. She'll be here soon. And that they were just, I don't know. So I appreciate you all. I will be live again at 6 p.m. to talk about the documentary Crash. Once again, I am going to talk a little bit about Mackenzie because we kind of have to, but most of what I want to focus on is male victims of IPV and also coercive control. I want to talk about parenting, so permissive parenting and some of the dangers of that. A lot of people have questions about her family. And so I can't talk about their specific situation, but I did have some thoughts based on the documentary. And so we will talk about that at 6 p.m. I appreciate you all. I will see you all next time. Have a good one. Bye.